Well, again, good afternoon. Thank you so much for joining us today for today's webinar on SB 9 and the end of single family zoning in California. Before we get started and I pass this over to our presenters, I just wanted to let everybody know a couple housekeeping items. Your microphones are muted and yes, your videos are disabled. But however, we really encourage you to utilize the Q&A button to ask our presenters any questions you may have. I'm also available in the chat along with one of my colleagues, Lewis. So if you have any technical issues, please utilize the chat and we can help you out on the back end. A couple other items, we will be circulating a copy of the PowerPoint, a copy of the recording, and any MCLE certificates that were requested by the end of the week. So please stay tuned for that and more information. Otherwise, I will pass this over to Steve Mattis, one of our presenters, to get us started.
Good afternoon, everybody, and welcome to our presentation today. Claire, Alex, and I are pleased to be with you today to provide some information regarding SB 9, SB 10, and SB 8. The primary focus today will really be on SB 9. We're hoping to provide you with a comprehensive overview, including actions that cities and counties should be thinking about taking now prior to the statutes taking effect. We have a large number of folks attending the presentation today. And so as Stephanie has indicated, we would appreciate if you would submit your questions into the Q&A. And then with the assistance of John Bacher later on from our firm, we'll actually go through and identify a number of questions and answer them at the end of the presentation. Claire, next slide, please. So as indicated, what we're going to cover today, and all three of us are going to speak at various times. We're going to cover SB 9 in pretty significant depth here. And we'll also talk about SB 10 and SB 8 to give you a really good overview of what these new laws mean and how they apply in the context of single family zoning, and for SB 10, process for potentially upzoning or streamlining the process for development up to 10 units on single parcels. The next slide. So we're going to start off with SB 9. And just at a very basic level, SB 9 requires ministerial approval of a 2-lot subdivision or in some instances, development projects for 2 units per lot. The proposed developments do need to include and do need to meet certain criteria. And with that, I'm going to turn it over to Alex Mogg now to talk about the criteria. Alex?
Thank you, Steve. The first criteria is, where are these projects allowed? And the projects must be on parcels that are zoned within single-family residential zones, parcels on which single-family residential use is allowed. And then they have to be within an urbanized area or urban cluster. And that's a definition that the Census Bureau has, and they designate what that means and classify areas. And this applies a little differently depending on whether the parcel is within an unincorporated area or within a city. If it is within an unincorporated area, then the parcel itself needs to be within an urbanized area or urban cluster. If it is within a city, it just needs to be within a city that itself has part of the city is an urbanized area or urban cluster. Even if the parcel itself happens to be in a part of the city that isn't an urbanized area or urban cluster. And that is a pretty broad definition. Almost every city in California has an urbanized area or urban cluster in it. There are a few, rural cities that don't have those areas, but all of the urban cities, all of the suburban cities qualify. Only really a handful of cities wouldn't meet that standard. Next slide, please, Claire. The law also identifies a number of areas and parcels where these SB 9 projects are not allowed. So the first is either the parcel has a historic site on it, or the parcel is located within a historic district. And that could be either under, state, federal designations, or also under a local ordinance. So if there's a local designation process, that qualifies as well as an area where an SB9 project is prohibited. And then the law identifies a number of, for lack of a better word, sensitive areas where these projects are not allowed. And we'll talk about some of those in more depth, but earthquake fault zone is one of them if it's in an area designated by the state geologist. Wetlands that are designated by the Fish and Wildlife Division. And one thing to keep in mind as we talk about many of these sensitive areas is they are generally sensitive areas designated either by federal government or state government. So we'll talk about the high fire severity zone a little bit later, but that's based on maps that CAL FIRE produces, not on a local determination that might be different from what CAL FIRE determines. They are permitted in coastal zones. However, some of you may be familiar with SB 35. The list of sensitive areas is the same that is in SB 35, except for coastal zones. And SB 9 projects are allowed in coastal zones. The projects still need to comply with all aspects of the Coastal Act, except that a public hearing for a coastal development permit is not required. Next slide, please, Claire. So one area to touch base on is one of these sensitive areas is that SB 9 projects are not allowed in FEMA designated floodplain areas, except there are some carve outs. So in the 100-year floodplain, you could still have a SB 9 project if you got a letter of map revision from FEMA, or you meet the minimum floodplain management criteria. Or if you're in a regulatory floodway, if you still satisfy all of the applicable federal qualifying criteria. So even if your project is in even if a parcel is in an SB 9 area, there are still some carve outs, and some of that area would be able to have SB 9 projects. Next slide, please, Claire. And then another important area to touch on is high fire severity zones. And these are maps that are put out by CAL FIRE, or they can be modified slightly by cities under a specific process. SB 9 projects are not allowed in high fire severity zones, except there are important carve outs. One, if the city or county has taken action to exclude the project site from a hazard zone, from a high fire severity project zone, then a SB 9 project would be allowed there. Or if the site has adopted fire hazard mitigation measures as set forth in the building code, a SB 9 project could be allowed there. So again, another example where the basic rule is these projects are not allowed in these areas, but there are carve outs and exceptions. Next slide, please, Claire. And then another one just to touch on is SB 9 projects are not allowed on areas subject to a conservation easement, on parcels with a conservation easement on them. So a conservation easement is a restrictive covenant that's binding on the current property owner and all future property owners that protects against future development in the area the easement applies in order to preserve that area as basically open space, as a scenic area. And one thing is you see conservation easements in a lot of areas sometimes that are developed, even highly developed, but maybe because of the topography of the area, there's steep hillsides on it that might get conservation easements on the hillside, even though there may be a house at the front of the parcel. And that lot would be exempt from SB 9 because there's a conservation easement on all of it. So next slide, please, Claire. And then there are a number of other areas that are identified in the law, certain prime farmland, hazardous waste sites that have been designated by the Department of Toxic Substance Controls, lands designated for agricultural protection under a local ballot measure. And similar things that these are, generally a little less common, but again, there are a number of sites that are exempt from SB 9 projects. And so if someone, the first step whenever someone comes to the city to apply for an SB 9 approval, you want to make sure the project is in the area where it's allowed. Next slide, please. And the law also contains a number of what we'll call anti-displacement measures. And these are, the legislature included these to protect against SB 9, leading to the displacement of existing tenants or existing affordable housing. We've seen this in a number of the housing streamlining bills that the legislature has passed in recent years. So an SB 9 project cannot involve the demolition or alteration of deed restricted affordable housing. In cities with rent-controlled housing units subject to rent control ordinances, housing withdrawn from the rental market in the last 15 years through the Ellis Act process, or housing that has been occupied by a tenant in the last 3 years. All of those, there could not be any demolition or alteration to any of those projects. Now, that doesn't necessarily mean an SB 9 project couldn't go forward. For example, if you have a tenant-occupied single-family home, a lot split to create a second lot on that parcel might have no impact. You could do that without demolishing or altering the existing single-family home with a tenant that's occupying it. But if you're involving the demolition, alteration of a structure, these rules would apply. And there are also some restrictions on demolishing existing walls, how many existing walls you can demolish in structures that have been occupied by tenants in the last 3 years. So again, it's important to be aware that these restrictions exist when you get an application. Next slide, please. And with that, I will turn it over to Claire.
Thanks, Alex. So based on the qualifying criteria, if the project meets those, what does the local agency actually have to do? I'm going to go over that in this next section. And the first thing that a local agency must ministerially approve is the development of up to 2 residential units. And for example, these could be 2 units or adding 1 new unit to 1 existing home that's on the lot. And the second thing is that the local agency has to ministerially approve a 2-lot subdivision. And there's certain rules about what the subdivision would look like. One is that each lot, the new subdivided lots, must be at least 1,200 square feet. The law does say that cities and counties can adopt a smaller minimum lot size for the approval, but the statutory amount is 1,200 square feet. And each lot must be at least 40% of the original lot. So this essentially means that the 2 subdivided lots could either be a 50-50 split or a 40-60 split, so that each of them is 40% of the original parcel size. And also, the lot cannot be subdivided if it's already previously subdivided under SB 9, so you only get to utilize it once. And also, the adjacent parcels can only be subdivided through SB 9 if the owners are independent. And I'll note that the statute, the word that's used under the statute is that the owner and the adjacent property owner cannot be acting in concert, so that nobody acting in concert with the owner applicant has been a prior SB 9 subdivider. The statute doesn't further define what does acting in concert mean, perhaps a partnership or some kind of agency. And that seems like an opportunity for local agencies to further kind of set the definitions under their own ordinance for that purpose. In the ministerial approval requirements, the local agency has limited ability to reject a project. The city or county can deny the housing development project or the urban law split if the building official makes a written finding based on a preponderance of the evidence, and that essentially means 51% of the evidence, that the project would have a specific adverse impact on public health and safety that can be mitigated or avoided other than to deny the project. And this is a very high standard to meet. And as some of you may appreciate, this is the same standard under the Housing Accountability Act, which is another law that is designed to kind of restrict local authority to deny housing development projects that meet objective standards and policies and plans. And so the definition under that law is also applied in this instance to restrict what kind of impact the local agency has to find before it can deny a project. And so it really has to be something that's quantifiable, unavoidable, direct, and it's based on objective public health and safety standards that are in place at the time that the project has submitted a preliminary application under SB 330, which we'll touch on a little bit later. But so this is a very high standard just because of the types of impact that's determined and the threshold of the evidentiary threshold that has to be met in order for these findings to be made. And for example, to illustrate, an inconsistency with the zoning with general plans is not an impact, is not such an impact under the law. So it is a very high standard to meet. So now I will turn it over to Steve for some requirements that can be posed.
Thanks, Claire. So Alex has talked to you about the types of properties that would not qualify for SB 9. Claire has talked to you about what cities need to do or counties need to do in terms of approval and the ministerial approval. This section is really geared towards what local agencies, cities, or counties are either obligated to do or can do in terms of implementation of SB 9. Claire, next slide, please. So first off, in terms of subdivision requirements, a local agency can require easements for the provisions of public services. So if you're going to have a second unit that's at the rear of the lot, you can require from a subdivision standpoint an easement to provide public services to the new unit. They can also require easements to ensure that both lots have access to a public right-of-way. So those are subdivision requirements, two of them that are allowed. What a local agency cannot require, though, is the dedication of new right-of-way, the construction of off-site improvements, or the correction of non-conforming zoning conditions if you were to assume that one of the residential units was already built and remains on the lot. Next slide. Local agencies, and the statute is very clear about that, they can adopt and may impose objective zoning standards, subdivision standards, and design standards through a local ordinance. I think this is a really important aspect of this. It is similar to objective design standards that we all saw with SB 35. However, it applies obviously to single family lots that are being either divided or having two units built on it on a single lot. So agencies will want to make sure that they have these zoning standards for single family lots adopted as quickly as possible, and presumably before the law takes effect on January 1st. There are certain restrictions to what the agencies can impose. Primarily, you can't have a setback requirement if the unit is built within the footprint of an existing structure. So if you have something that's already legal non-conforming use in terms of where the structure is, then the new unit can be built within that same footprint. And you also cannot require more than a 4-foot setback from side and rear yards. Significantly, the standards cannot physically prevent development of a unit that's 800 square feet. But that doesn't mean that cities can't adopt standards that would limit development that is proposed to be over an 800 square feet unit. So that's something that I think that cities and counties will have to consider in terms of how they want to implement SB 9 as we go forward. We'll talk more about the objective standards later. Claire, next slide. The agencies are also required to prohibit short-term rental of any units created through SB 9. So if you create additional units, they can't be used either if they're created on a second unit on the same lot, or if you have a subdivision, you can't, and you create 2 lots, you can't use any of the units for short-term rentals. For lot splits, an applicant is also required to submit an affidavit that the applicant intends to occupy one of the units as his or her principal residence for at least 3 years. Beyond that, you cannot impose, or cities and counties can't impose any other owner occupancy standards. Next slide. SB 9 also talks about parking restrictions, and it provides that cities can require a maximum of 1 parking spot per unit, except no parking can be required if the parcel is within a half mile of a high quality transit corridor or major stop, which itself is an existing rail or bus rapid transit station, a ferry terminal, or fixed bus route services with intervals no longer than 15 minutes during peak commute hours. Or you also cannot require 1 parking spot if the unit or the parcel is within 1 block of a available car share vehicle. And so this is something that agencies will have to look at in terms of identifying the area that is within the half-mile radius, and then have the parking standards appropriately applied. Next slide. For accessory dwelling units, SB 9 did try to address the issue of both splitting the lots or adding second units, and then availing yourself of the rights for ADUs under California law or for junior ADUs. So the local agency can prohibit ADUs and junior ADUs when the lot is subdivided pursuant to SB 9, when there are 2 units existing or constructed on each lot. So once someone is subdivided, and if they put 2 units on a lot, then they cannot also avail themselves of the rights to ADUs or junior ADUs. This is also applicable when both the subdivision and the housing unit constructions are done via SB 9. So if they're doing the 2 lot subdivision first and then building 2 on each, as I just indicated. There is a question about whether or not the 2 unit project that is on a property that isn't subdivided, it looks like there's an argument that one could still do potentially ADUs and junior ADUs on that under the law as it's written right now. I suspect there will be some clarifying legislation on that, as we saw with the ADU statutes when they were adopted, and then there was some cleanup legislation adopted after that. Next slide. Alex has spoke to this a little bit already, but there are relationships to other laws that I think are really important. Under SB 9, the projects themselves, so the lot split or the construction of the additional unit, are exempt from CEQA. And importantly, the adoption of local ordinances to implement SB 9 is also exempt from CEQA, which I think will facilitate cities and counties who need to adopt ordinances fairly quickly to be able to do those without having to comply with CEQA, because the statute specifically says those ordinances are not a project under CEQA. Also, in terms of the Coastal Act requirements do still apply, but as Alex indicated earlier, the local agencies do not have to hold public hearings for coastal development permit applications for SB 9 lot splits. And so at this point, we want to take all these slides and show them to you in terms of illustrations, how they may play out. So I'm going to turn it over to Claire for that. Claire?
Thanks, Steve. So as we said, now we've been throwing law at you for the past 20 minutes. What does it actually look like in illustration? And first, you really want to consider 2 things, right? Does the project meet SB 9 requirements? And these include the kind of the single family zone, urban cluster, anti-displacement requirements that Alex went over. And the project, is kind of like a checklist, checking off and see if they meet those requirements. And plus, is the project in a permitted location? And this really is, they're not in a prohibited areas, historic sites, fault zones, floodplains, other sensitive areas. And after that, it really comes down to being able to construct kind of the three major types of developments. One is a 2-unit project that does not require subdivision. The other is just a lot split. And the third one is the 2-unit plus the lot split that utilizes both of SB 9's provisions. And we have some low tech, but hopefully visually informative illustration of what this looks like. And so for a 2-unit project, existing lot, existing home, no subdivisions, you get 2 units on it, 52 new units, 1 new plus 1 existing, at least 800 square feet with objective standards that's imposed by the local agency. The applicant may be able to get an ADU. As Steve mentioned, that the law is a little unclear on this aspect, so that's maybe the case. And also setbacks, they can encroach up to 4 feet from the side and rear yard setbacks, but no setbacks if the structure is within the existing building footprint. And also parking 1 spot per unit unless the parcel is a half mile from a major transit stop or 1 block from a car share vehicle. So on a lot split, the requirements carry forward to this as well, but I do want to illustrate some unique requirements as to a subdivision. Like I had mentioned, each new lot that's created has to be at least 1,200 square feet under the statute. And the split is approximately, 40-60 or 50-50, making the lots kind of similar size to each other. And again, the CPRA provisions do not apply to this lot split or the 2-unit proposed development because they're ministerial projects. And with the lot split, no right-of-way dedications or new offsite improvements may be required. And in combination, the 2-unit project plus the lot split, it's really all the requirements that are carried here, with the exception that the statute is specific that there's no ADUs that can be the statute, it says that local agencies do not have to permit ADUs. So presumably that would mean that no ADUs could be permitted unless the city or county otherwise permits. And in all 3 scenarios, none of the units that ends up being created may be used as short-term rentals. And here's a summary chart of really the 3 scenarios of development, and it compares to what it looks like comparing to each other. And as you can see, the one kind of difference is that ADUs may be allowed under the 2-unit project, and where the other 2, there's no ADU, and also owner occupancy affidavits are required for these other 2 scenarios. So I will turn it over to Alex for some next steps.
Thank you, Claire. So you've just heard a lot of information about what this law requires, and the question, it goes into, in effect in basically 90 days, almost exactly. January 1st is when this law goes into effect, and people can start applying for these types of projects. So what are next steps for cities and counties to consider? Next slide, please, Claire. So first, there are just some forms that would be helpful for city and counties to prepare just so they're ready. So the first is, we've mentioned that SB 9 units created through SB 9 can't be used as short-term rentals. So you'll want to have a deed restriction prohibiting units created through SB 9 from being used as short-term rentals. Similarly, an SB 9 project can only, a lot split can only happen once. And once that lot is split, the uses have to be for residential purposes. So another deed restriction that cities and counties may want to develop is a deed restriction prohibiting future SB 9 lot splits once the first lot split occurs and any non-residential uses on those lots. And then also an affidavit for an applicant to sign you know, representing that they will use one of the units as their primary residence for at least 3 years. So next slide, please, Claire. And as Steve mentioned earlier, the law allows cities and counties to enact objective zoning standards regarding SB 9 projects, as long as those standards do not physically prevent a unit that is at least 800 square feet. And I'm sure most of you know already, but this law already includes a definition of what an objective standard is, which is the same as the definition in the other streamlining laws like SB 35 and is similar to common understanding of what objective means. But an objective standard is a standard that is uniformly verifiable and involves no personal or subjective judgment. So taking a height limit, for example, a requirement that says no building shall be over 20 feet, that's an objective standard. Everyone can go out and measure the building, and everyone should get the same height when they're measuring that building to know whether or not it complies with that requirement. A subjective standard, or a standard that isn't objective, might be a height limit that says buildings shall be a similar height to other adjacent structures. People could view, what does similar mean? That's open to interpretation. And so different people could reach different results. Next slide, please, Claire. So like Steve mentioned earlier, like we've mentioned, cities have the ability to adopt these objective standards, and as long as they don't limit, as long as they wouldn't prohibit a unit from being built that's at least 800 square feet. So that's a potentially valuable tool in communities that don't want or want to limit the number of these types of projects. If lots are extremely expensive and all you can build on it is an 800 square foot home, it may not be worth, someone may not find it economically feasible to buy a newly created lot that might cost hundreds of thousands of dollars if all they can build on that new lot is an 800 square foot home, which is relatively small. Now, of course, in areas where the land might be cheaper, or in areas where there may be certain demand, that might not be an issue. But in some communities, that could defeat, discourage people from doing this. If they are, have to spend $1 million on the lot, they may want to build more than a 800 square foot home there. I know you see in the Bay Area often, tear downs of, you buy a lot for a lot of money and you tear down the existing structure and you're paying a lot of money there just for the land. But after that land is bought, you're not generally building an 800 square foot structure there. So it's a tool for cities and counties to consider. And cities and counties may have other design standards they want to implement. Many agencies are going through the process or have already gone through the process to adopt objective standards in response to other housing streamlining laws like SB 35. But many of those might only apply to multifamily housing projects, not single family units. And so agencies who want to should really try to adopt standards, even if it's just sort of a first crack at the standards by January 1st, and then have them amended later on. This is very similar to ADU legislation, where I know, as those bills came out, sometimes people would adopt the ordinances, some cities or counties would adopt ordinances and then change them, modify them, refine them over time to get exactly what they wanted when they had more time to think about it. Or if your community or your city or county is comfortable with just the minimum requirements in SB 9, then there's no need to adopt anything more than that. Next slide, please, Claire. And just some additional factors to consider. One, SB 9 regulates local agency authority, the planning and approval authority for cities and counties. It does not preempt HOA rules or CC&Rs. The legislature has done that previously with ADUs, but SB 9 does not do that. So CC&Rs and HOA rules continue to apply. And another question that is often asked is, are affordability requirements allowed? And the law is silent on that. The law does not say one way or another whether a city can a city or county can impose affordability requirements. Some of the supporters of the bill, including legislators who were co-sponsors of the legislation, have said it's allowed, but it's not addressed one way or another in the legislation itself. And the Supreme Court has, in California Building Industry Association versus City of San Jose, the California Supreme Court has ruled that inclusionary housing requirements that a certain percentage of units be affordable for multifamily housing construction, has said that's legal and that's allowed. I think it's somewhat of an open question whether the rationale behind that decision regarding multifamily housing projects would apply to SB 9, where it may not be, there may only be one unit being created through SB 9. And so an affordability requirement could have a much bigger financial impact on a property owner or a developer than a normal inclusionary housing requirement that might only apply to 10, 15% of units. So that is the status of affordability requirements. Next slide. With that, I will turn it back over to Steve.
Thank you, Alex. And I wanted to call everyone's attention, for those of you who have not had the opportunity to see the Turner Center out of Cal at UC Berkeley. The Turner Center did do an analysis of what they thought would be the likely level of development after SB 9. And I do commend that to folks for reading, because it does suggest that there are many factors in terms of economic feasibility of building the additional units that would likely result in a relatively small percentage of units being built or lots being split under SB 9. It is a significant number, even if it's a small percentage of the number of single family lots, but it is a study that I think is interesting, and it provides some economic context to the issue of SB 9. Turning over to SB 10 and SB 8, which I'll address pretty quickly, and then we'll open up for questions. Claire, next slide, please. SB 10 authorizes, and it's important to understand that it authorizes, it doesn't mandate, legislative bodies to zone any parcel for up to 10 units of residential density. So a 10-unit apartment complex. It authorizes the legislative body to actually override local initiative measures, but requires a 2/3 vote for the legislative body to do that. So if an entity, if a city or county wanted to allow development of up to 10 units on a parcel, and they had to deal with a citizen-sponsored measure that had been adopted, it would require 2/3 vote of the legislative body to override that. The ordinance, the conforming general plan amendments, and the other changes in the regulations are specifically not projects subject to CEQA. So when a city or county opts to adopt some zone changes, general plan amendments that would implement SB 10, again, assuming they want to do that, that decision itself is not a project under CEQA. The parcels themselves that are available for this must be in transit-rich areas or urban infill sites, and must meet certain other local requirements. And most importantly, the local agency retains the authority to decide whether or not to make the zoning change. So this is an issue that will come up likely for parcels that are obviously near transit centers. And it will be within the authority of the local legislative body to decide whether they want to effectively upzone parcels that wouldn't otherwise allow for up to 10 units. Next slide. So I'm going to briefly talk about SB 8. SB 8 is really an extension of the laws under SB 330, which is the Housing Crisis Act of 2019. As those of you who have worked with SB 30 will realize that it was intended to, for instance, make housing development projects only be subject to the ordinances, policies, and standards adopted and in effect at the time that a preliminary application was completed. And it essentially tries to incentivize and allow for there to be a fairly level playing field for purposes of new housing development. Some of the law was originally scheduled to sunset in 2025, but significantly SB 8 extends those provisions to 2030. Claire, next slide. So some of the provisions that are extended to 2030 include that the jurisdiction cannot disapprove a housing project or approve it at a lower density if the project complies with the applicable objective standards that existed at the time of a complete application. There are also changes to the project that are allowed, including increasing the number of units or square footage by up to 20%. That provision is carried forward. And it requires or it extends the time period to 2030 where a complete application is required within 180 days after submission of the preliminary application. And now it extends the time period within which construction must start from 2.5 years to 3.5 years for affordable housing projects, not for all residential developments, but just for affordable. And it also extends what many of you will recall was the 5 hearing limit for certain projects with complete applications. So that's the 5 legislative body hearings that were provided for under SB 330. Next slide. So with that, we are at the conclusion of our presentation. We are happy to answer any questions that folks have. As we indicated early on, our partner John Bacher has been kind of monitoring the questions in the Q&A, and we're going to go off the PowerPoint slide now. John will kind of select some of the questions and pose them up to us. And John, if you stump us with any of the questions, you have to answer the question yourself. So with that, we will turn it over to you, John.
If it comes to that. We got several questions about the affidavit requirement and how is that possibly enforceable? And remember, what the affidavit requirement says is that an applicant must submit an affidavit that indicates that they intend to live in one of the units for 3 years. So how is that possibly enforceable? Alex, you have a response to that?
Well, I think that, the requirement is pretty clear that it is simply to submit an affidavit saying it's your intent to live there for 3 years. And the law is also pretty clear that cities cannot and counties cannot require any additional owner occupancy requirement. So I think to the extent that there is a requirement that the city will actually, be checking that these are occupied in that way, it really isn't that enforceable. It's not, the law doesn't seem to give cities and counties any authority to enforce that if someone doesn't want to comply. The lot split will already have happened. You will have the affidavit that maybe wasn't truthful, but at that point, there's not much practically you can do. Theoretically, the affidavit is signed under penalty of perjury, but I don't think any city or county, is gonna try to bring any sort of action regarding that.
I can't imagine a DA being very interested in prosecuting someone
Exactly
for that, unless it were something that continued over multiple projects and became something that was fraudulent. Okay, so I guess the next question that really several people had was related to the definition of single family zone. Remember, the Act only apply, or SB 9 only applies to projects and lot splits in single family residential zones. And so various people were pointing out, well, we have zones in our community, multifamily zones, that allow the same uses that are allowed in a straight single family zone. So could a property owner do and Steve, I'm going to pose this one to you. could a property owner propose an SB9 project in what is effectively a zone that allows both single family uses and multifamily uses?
Yeah, I think the statute is clear that it is properties that are zoned single family. And so,
Only,
in most
single family only is what you say.
single family only, correct. And most general plans and zoning do pretty clearly define the single family zones. They may have some, there's obviously some variations in density that apply within a single family zone if you're rural residential, if you will, or if you're another type of residential in a more urban area. But the law is really intended to apply to zone properties that are primarily zoned and exclusively zoned single family. So I don't think that where an ordinance, for instance, allows multifamily zone, but allows multifamily on a parcel, and the parcel itself is designated multifamily, but the ordinance allows the development of a single family lot, I don't think that would be a qualifying lot under SB9.
Steve, here's this kind of a related question that was posed in the Q&A, which is, let's say the general plan designates the parcel for a single family, but the zoning is inconsistent with that and maybe allows multifamily. So one couldn't pursue a multifamily project on that site because it's designated multifamily. I'm sorry, because it's designated single family. But the zoning is not single family. Could one pursue an SB9 project in that context? I think that might be a Zen Cohen, because that one is, I'm not sure the statute really addresses that, but do you have any thoughts on that?
Again, I think you do have to look at the hierarchy of the land use documents within the city. And so if you do have property that is designated under the general plan as single family, and that's the primary controlling document, then it is likely that it would qualify under that. We'll look at that further, and when we offer further answers, if we don't get to all the questions today, we can expand on that a little bit too, because there are instances where people have inconsistent zoning, but inconsistent zoning generally shouldn't override the general plan.
Okay. There were several questions about, well, how many total units can you get? How is somebody going to do a sequential ADU? How many ADUs could you do on an SB9 lot split project? So can we try to see if we can elucidate that a little bit more, Claire? How many ADUs are allowed in combination with an SB9 project? And then one other thing to address in that is how would SB9 apply to a scenario where there's an existing ADU or JDU on the site, or an existing, maybe even two ADU, well, an ADU and a JADU on a single site? How many total are there? And I think I just saw a chat item flash in front of me, like indicating that Tony Atkins is saying you can do up to 6. So is that possible, and how?
Yeah, so the statute defines a unit to include a primary unit, an SB9 unit, an ADU unit that's created pursuant to the ADU statutes. So all of that would count towards the number of units. And so if you have a new lot that's created through the SB9 subdivision process, and then you have 2 units on top of that, the local agency the law says that agency does not have to permit additional ADU units once you have met that 2-unit threshold. And so if the local requirement does not allow additional units, then it would be the 2 units that you would get under SB9. If it's just a lot and it's a 2-unit proposed 2-unit development on it, the statute is silent as to whether or not ADUs have to be required. And so potentially that could mean that property owners do get additional units on top of the 2 units that's being built under SB9. All of that in my opinion, seems a little contradicting to what the intent of the statute is. If it, says that you're going to have up to 2 units. And so that's where it stands now. And likely there'll be some interpretation or cleanup statutes after that to address it. But so as it stands now, if the local agency does not otherwise prohibit ADUs for a subdivided lot with 2 units, then potentially you could get more units. But if it does prohibit it, then the 4 units on 2 urban lot splits is what you would get under the statute.
One question that this is a question for me, and I'm not sure that there's an answer to this, but ordinarily one could do a condominium map via parcel map. And so I was looking at the statute, and it refers to SB 9 lot splits as urban lot splits. And to me, I wonder if that precludes someone from doing a straight airspace condominium in a way that might, well, can someone do an airspace condominium where you have a stacked 2-unit project? Can you create a stacked parcel, or is that not considered a lot split? Steve, do you have any thoughts on that?
I mean, I do think that the statute allows the city to establish the design standards, including like heights. So I think you could, I think you could have a stacked development. I don't think you can exceed the number of units that are allowed. And there is language in there that specifically talks about, the alteration of certain walls within the existing unit. If you retain the existing unit, would suggest to me that you could go to a duplex or a condo type arrangement where you have airspace. But the statute is pretty clear about what the lot split is, and that's really splitting the lots themselves as opposed to anything else.
Right. Okay. Alex, you know a fair amount about SB 330. One of the questions posed was, if you're adopting objective standards to deal with SB 9 projects, isn't there some way in which SB 330, which basically precludes downzoning, isn't there a way, doesn't SB 330 operate in a way that would prevent you from adopting SB 9 standards that have the impact of sort of precluding what SB 9 would otherwise allow?
So SB 330 prevents, the exact wording is escaping me, but I think you can't decrease the intensity of housing in an area. And so, for example, if you decrease a height limit from 100 to 10, even though you may not have decreased the density allowed there, in effect, you've downzoned the property because you just simply can't build as many units there as you may have been able to before, even if you don't change the density. With SB 9, since the law is already pretty limiting on what you can do, you don't have the chance for hundreds of units. We're talking about 2 units. So deciding you wanted to allow only units up to 800 square feet does not limit the number of units on site. It might limit the size of the units that you can build, but it's not downzoning. It's not decreasing the number of units that are possible. Other types of objective standards you might, design and objective standards, might limit what you can build or require you to do certain things with windows or with, decorative features or any of those things that might make a project more expensive or require it to be sited a certain way or to be a certain size, but it doesn't eliminate or lower the number of units you can have. So in that sense, I don't think SB 330 would impact your ability to adopt any sort of objective standards as to SB9 projects.
Okay. There are a few questions about the 800 square foot requirement, and the language in this statute is a little bit ambiguous. So, Claire, can you talk a little bit about what the language limiting objective standards relative to the 800 square foot unit requirement? Can you try to explain that in a little bit more detail?
Well, the requirement of the statute allows the imposition of objective standards, but the standards cannot physically prevent the construction of an 800 square foot unit. And so, for example, even though the statute says that setbacks can be required up to 4 feet front or side and rear yard, if that kind of standards precludes the construction of the 800 square foot unit, then that cannot be required. Or if there's a height requirement that precludes the construction of the unit up to 800 square feet, that also cannot be required. So it's really the standards can be in place, but if the physical construction would be obstructed, then that would not be permitted under the statute. It's similar to how the ADU statutes operate.
So, Steve, do you think that you could adopt, a jurisdiction can adopt specific objective standards that apply only to SB9 projects? Is that how you understand the objective standards language in the statute, such that you might have a different height limit, for example, that applies to SB9 projects than maybe you do for other projects in that zone?
So the answer to that, I think, requires looking both at SB9 and SB8. So in general, because objective design standards that have been adopted for the most part to date have been for SB35 type projects, which are multifamily. Cities that don't already have objective design standards or haven't kind of packaged them all together as their objective design standards, I think probably will want, and same with counties, they will want to adopt objective design standards for single family units that are SB9 projects. SB8 does specifically extend the reach of SB 330 to single family lots. And so I do think that if you were to ultimately have some way of netting out less units, then that could be less units than are allowed under SB9. Then that could also put you at risk for SB8 and SB 330 that you would be effectively doing that. Given that the number of units that SB9 allows is, really it's mostly 2 and 2 if you subdivide. There's some question as to how many you can get with ADUs if you don't subdivide. But I don't see that cities' objective design standards would necessarily take what would be like a number 4 down to a number 3, because I don't think you can do that under SB9, assuming you do a lot split. And I also think that practically it's not going to, I don't see it. I don't see very many scenarios where a city would be able to change the zoning in a way that would actually net out fewer units because SB9 already allows just a limited number of units with the lot splits. I would say, John, I wanted to add a little bit more to one discussion we had earlier. SB9 uses the term residential zones throughout it, whereas SB8 and SB 330 uses the more expansive kind of general plan zoning type language. And so I do think I think that's relevant to the scenario where you have inconsistency, but practically if people have inconsistency, then they've generally been dealing with their inconsistencies through their zoning updates anyway.
Okay, well, we've run out of time, but I just want to make a couple comments. I tried to keep up with the questions, but boy, I think we have 111 questions in the Q&A, and there are probably more in the chat that we didn't pick up. There were a couple I just wanted to comment on. There were several questions about how exactly the fire standards apply, and somebody noted that the building code might preclude development in some fire zones anyway, and that's true. That would be an objective standard that might, if that's true, that would be an objective standard that wouldn't allow a project like this in any event. And so we'll look at those fire questions and see if we can provide some answers to the individuals that pose those. And similarly, there were a few questions around the Coastal Act as well. Those didn't have general applications, so I chose to not try to answer them, but we'll try to follow up with some of the folks that asked those questions and respond accordingly. So Steve, I'll turn it back over to you. We're done with Q&A.
Thanks, John, and thanks everybody for joining us today. We will try with we won't try, but with the additional answers that we provide out that John was referring to, we'll distribute those to the entire group so that everybody has an opportunity to see them, even if you weren't the specific party requesting it. For those of you who work with us at Myers-Nave already, you can appreciate that that we will have very specific discussions with local agencies that are going to be attempting to comply with SB 9 and getting ready to comply with SB 9 as we move forward. Last comment would be is that I would anticipate that there will be some level of cleanup legislation that happens so that we get clarity on some of these issues that have been raised, including the exactly how you count the ADUs when you don't split the lot. That seems like something that is ripe for clarification. So with that, we thank you all very much for joining us today, and we appreciate your time. Thank you. Thanks, Claire. Thanks, Alex.